Good
Thank you,
morning,
sir.
all of you. At the very outset, I must make it clear that within a span of 1 hour, it is not possible to cover up the issues which are assigned to me. But I will be trying my level best to give you bird eye view of the subject matters which are given to me for today's discussion. The proof documentary evidence, how to prove the documents in the court of law, public document, private documents. So before begin and before touching to the subjects directly, I would like to take you through the theme of this Indian Evidence Act. In the year 1872, this act came to be enacted. In the same year, Indian Contract Act was also enacted. On the same day, both acts came into force. 15th of March 1872. James Stephenson drafted this act, and I believe that this is the act which is drafted scientifically, even on the parameters of the scientific criteria. This act is still proving to be helpful in the court of law before and other judicial authorities before whom the evidence is recorded. This act consists of three part, 11 chapters, and basically, if you see, I always say that WWH means this Indian Evidence Act speaks about what, why, and how. WWH, what I say. So, Evidence Act talks about of what means the evidence of fact. Evidence of what? The evidence of fact. The second W denotes why, to prove fact, and H suggests how. How answer is in the manner which is provided under the Indian Evidence Act. So evidence of what? The evidence of fact. Why? To prove the case of the prosecution, to prove the case of the plaintiff, the defense of the defendant, whosoever claims before the judicial authority, be it the court or the quasi-judicial authority, claims anything, he has to prove. Burden lies upon him to prove. So what we all do, that he or she or the plaintiff or the defendant, the petitioner or the respondent, as the case may be, they need to prove their allegations. So allegations means their fact which they allege. So evidence of fact and the manner in which it is to be conducted before the authorities, the court, is the manner which is provided under the Indian Evidence Act. And each section is drafted so scientifically that even logically, analytically, we hardly felt any need to amend this act. Because of the need of the hour, we have recently amended this Indian Evidence Act. In past, certain presumptions have been incorporated. The moment the Information Technology Act came into force, as a necessary consequence, this act was also amended suitably, introducing the electronic record in the Indian Evidence Act. And thereafter also certain presumptions have been incorporated by virtue of the amendment in view of the infamous incident which had occurred at Delhi. So coming to the meaning of this fact, when I'm repeatedly using the word fact, fact means what? Anything, state of thing, a relation of thing capable of being pursued by the senses. See, what we need to prove in the court of law is the fact only. True or false, we are not bothered. The Indian Evidence Act also doesn't talk about true or false, but it talks about only fact. Anything. So fact means what? Anything. State of thing capable of being perceived by senses. Now see, anything. PC is before me, laptop is before me, AC is on, mouse is in my hand, anything. Mouse, fan, tube light, furniture, anything is a fact. State of thing, fan is running or moving is a state of thing. Light switch on, switch off, state of thing. But it should be capable of being pursued by senses. You know how many senses are there? You know, capable of being pursued by senses. See the word capable. The word being pursued by senses is not employed here. Capable of being pursued by senses. This word has also meaning. Anything, state of thing, relation of thing, perceivable by senses, not capable of being pursued by senses, is a fact. Second definition is the mental condition of which person is conscious is also fact. Mental condition of which person is conscious is a fact. So two categories have been incorporated in the meaning of the fact. Means and includes anything state of, I'm repeating, anything state of thing, relation of thing capable of being pursued by sense is the fact, or a mental condition of which person is a conscious is a fact. Mental condition of which means that sometimes something is going on in your mind, that is a fact, but cannot be pursued by my senses. Even if you are two friends, one is sitting beside you, what he is thinking you cannot pursue, but mental condition, this means motive, the reason for commission of the murder. Of course there must be motive. Without motive nobody would commit murder or commit any offense. Motiveless murders are hardly seen. Ill will, these are the reputation cannot be pursued by senses. I give example that Mr. Anna Hazare has a reputation in the society. Is it capable of being pursued by senses? But this is a mental condition. We know that Sri Anna Hazare has a reputation. Gandhiji is respected. Dr. B.R. Ambedkar is respected. Mental condition of his person is conscious is a fact. So if a person had motive to commit any offense is also a fact. Anything means what? Sky, moon, sun, earth, anything, the village, cities, the world we see by open eyes is a fact. Capable of, is there in the atmosphere, is there air? Air is there. We exhale, inhale the air, which is why we are alive. That is also fact, but we cannot perceive it by open eyes. But still, it is a fact. Anything, whatever we can see is a fact. Whatever we can hear is a fact. Whatever we can perceive by sense is a fact. Capable of being perceived by senses. And the things which are not capable of being pursued by senses is not a fact. Whether I put question whether there is a moon in the sky. If you see now, right now in the sky, you will not notice it that there is a moon. Whether there are stars in the sky, you will not perceive it by open eyes right now. But you can see when your capability is enhanced. When your capability is enhanced means some mechanism will have to be employed or applied so as to see the stars. By using mechanism, we enhance our capability and thereby we pursue. So if you apply certain machinery, then other example, the room in which you are sitting, there are bacteria. Can you pursue those bacteria now? Can you see? Can you feel that there are bacteria in your room? But we know that bacteria are omnipresent. They are everywhere. But you cannot see you by open eyes. You cannot perceive it. But you can perceive it if necessary mechanism, tool is applied, machine is applied. So we applying that machine or tool, we enhance our capability and thereby we pursue. And we come to know this is the bacteria, this is virus. Coronavirus, can you see? But it exists. You cannot see by open eyes. There is a specified mechanism. Tests are to be applied to ascertain whether somebody is infected by coronavirus or not. Then those machinery, those tools, scientific mechanism are applied. Then we enhance our capability to recognize the things, to ascertain that somebody is infected with COVID-19 or not. Then we come to know that a person is infected by COVID-19 by using scientific tools. These scientific tools, what they have done, they have enhanced our capability to understand the things. So whether coronavirus is or not is a fact, because by using that machine we have come to know. Otherwise we would not have come to know that there is a virus like corona. So anything, state of thing, relation of thing capable of being pursued by senses. Then common example which we come across during trial of criminal cases. A commits murder of B by knife and the knife has blood stain. But whether the blood stain, we can, by open eyes, we can recognize that this is blood stain, but whether this blood belongs to the victim or not, what is the blood group of that victim and the blood group which is on the knife, blood stain on the knife or the clothes are the same, then we will have to refer it to the forensic laboratory. Then scientific expert, he also does not say by open eyes, no, this is the blood group A, B, C, D. He has to apply certain mechanism. Thereby he comes to know, he comes to the conclusion this blood group A on the on the knife and the blood group A of the victim. Now it matches each other. Then we come to know that this is the fact. This mechanism has enhanced our capability to recognize the things. So this is the fact, and this fact will have to be proved in the court of law by either of the parties to prove the fact in issue, which is also the word used in the Indian Evidence Act. Fact in issue, what are the facts? A commits murder of B, prosecution alleges so. So what is the fact in issue? Whether A has committed murder or not, within the meaning of section 299 and punishable under section 302 of the IPC. Then the trial before that entire trial hinges on the point whether A commits the murder of B. And if he commits the murder, if it is found by the court, then court will punish him as per law. That is the fact in issue. We are concerned with the document. The document, when we ordinarily see the definition, document means the pages which ordinary picture comes in our mind is the pages, books. But if you see minutely the definition of Indian Evidence Act provided under section 2, it says document means, for your ready reference, means any matter expressed or described. See minutely, any matter expressed or described upon any substance, by means of letter, words, figures, or any of them, or more of them, intended to be used or which may be used for the purpose of recording the matter. For the purpose of any matter expressed or described. If you see, when we walk on the road, public road, highway, so many display boards we notice. Some arrow is there. If any arrow is shown directing to the right side, nothing is written except that mark arrow. What it suggests that you have to take right turn. If the arrow shows left side, then we understand that one has to take left turn. There is nothing expressed or expressly written that you take right side, but arrow simpliciter is there. When you go to washroom, you see the images, image of a man, image of a woman. Then you come to know that no, this is the lavatory or the washroom where the picture of a man is affixed, then men are allowed, and the picture of a woman is affixed, then the women are allowed. Women are supposed to go there. There is nothing expressly mentioned that only women are allowed, but we understand it. Anything, any matter expressly expressed or described upon any substance on earth, so as to preserve that matter, so as to make a record of it, and this described or ascribed or expressed by means of letter, words, or figures, or any of them, or one of them, or all of them, that is called a document. Now, example: an agriculturist working on the agricultural field, suddenly snake bites. Now he realizes that I am now going to die. Then, therefore, he writes it down on the earth. He simply writes that after my death, my son A shall inherit my property, or I want to devolve my property, this field, to my son A. And he makes a sign on earth. No paper, no pen. Whatever that a person who is going to die has written on earth, whether it is a document. Second example, if you recollect, or if you have seen any in Hindi movies, it used to happen in earlier movies that relatives of hero or heroine assaulted by a villain and he is likely to die, or he is dead, or he is killed. That person who is supposed to die or going to die, he writes by his blood on a wall, Shakal or Kallu. Then hero comes to that spot and he asks that victim who is no more, kaisa ho gaya, kisne mara? Nobody is there to answer, but that hero then watches that wall on which there is something written, Shakal, by blood. Whatever is written on that wall by blood, is this document or not? Now see, if you see minutely the definition of the document, then it is also a document. Whatever that agriculturist has written is also a document within the meaning of the Indian Evidence Act. There are certain examples given to understand what is the document. I will take you through that illustration. Number one, writing is a document. You know, everyone knows it. Word printed, lithographed, or photographed are document. Map or plan is a document. And encryption on a metal plate is also a document. Caricature is a document. Encryption on metal plate. See, a board is displayed outside your house or office showing advocate XYZ. That is also a document within the meaning of the Indian Evidence Act. So ordinarily concept only papers they are to be considered as a document. That is not correct. One, whatever is written by means of words, figures, or marks, so that a record of it is prepared, that is called a document. When you go on highway, you notice that particular Thane 100 kilometer, Mumbai 100 kilometer, or Nagpur 100 kilometer is away. So whatever is inscribed on that stone is also a document. One more development has taken place. The electronic record is also given the meaning of document. Electronic record is also a document within the meaning of the Indian Evidence Act. Why? It is not expressly included in the definition of the document, but if you see the meaning of the evidence as provided under the Act, evidence means oral statement made by a witness before the court is called oral evidence, and the document and other kind of evidence is documentary evidence. See, all documents including electronic record is called a documentary evidence. So kinds of the evidence: oral evidence, documentary evidence, as is recognized by the Indian Evidence Act. But we have classified during the course of the judgments, or by giving thoughts on this subject, we have developed it. The courts have, honorable courts have developed it. We have called them, we have developed that witnesses, the circumstantial evidence, the oral evidence, documentary evidence, the witnesses, child witness, dumb witness, rustic witness, chance witness, natural witness, trustworthy witness, incredible witness, hostile witness. We are giving such branding to the witnesses, but each one has meaning. Each witness, the names which I have given you. Hostile witness means a person who does not support the side who calls him as a hostile witness. Natural witness is called the person whose presence is natural on the spot of the incident or accident, or whatever incident occurs, he becomes witness because of his natural presence. Chance witness is a person who by chance has been there on the spot, and because by chance something happens, he becomes a witness by chance. Rustic witness, a person who belongs to the village area, having no understanding of law and the other the affairs of what happens in the society. Rustic witness. So we have branded. Indian Evidence Act does not recognize such word. So oral evidence, you everybody knows, whosoever comes in the court states before the court, that is called the oral evidence. And the documentary evidence, including electronic record. Documentary evidence means the document which I have now explained to you, that is a document. One more addition in that definition is now the electronic record is also a document within the meaning of the Indian Evidence Act. This has been done after introduction of the Information Technology Act. But see, the way back in the year 1963, and prior to that also, the Supreme Court of India had occasion to deal with this subject. If you know the case of Indira Gandhi's election, that was fought, and there were certain recordings, telephone calls were recorded illegally, and the recorded version was placed before the court. So within what meaning this will come? Indian Evidence Act was silent. There was no express provision in respect of the recorded version. The Honorable Apex Court has held that it is also a document within the meaning of the Indian Evidence Act in much before. Now we have expressly introduced this concept of electronic record, and we have recognized it it is an documentary evidence within the meaning of the Indian Evidence Act. So having been understood, evidence of what? The fact. Why? To prove the case, to prove the allegations, the assertions made by the parties, and how the manner in which in which the Indian Evidence Act provides. So a fact will have to be proved the way in which this Evidence Act specifically has provided. It has also provided if anything happens or if there is any irregularity in introducing the evidence or tendering the evidence or while leading the evidence, still evidence does not go away. Evidence is not washed out. Material, if there is no material irregularity, that can never be the ground for rejection of evidence, which has been expressly provided under the Indian Evidence Act. Now, the fact must be direct, must be related to the fact in issue. What fact is to be proved? The fact which a party is going to prove must be relevant. Irrelevant facts are not to be proved and will not be considered. And now, relevant fact is said to be relevant when they are interlinked with each other, are so connected. I will give you two illustrations to understand the relevancy of the evidence. This is a common phenomena in Hindi movies. It happens that a girl calls brother. She calls and she informs to her brother, भैया भैया मेरे जान को खतरा है, जल्दी आ जाओ, telephonically. And her brother has a cell phone of Idea company, SIM card of Idea company, and he is at the distance of 1 kilometer from the house. She calls up to her brother, भैया भैया मेरे जान को खतरा है. He asks, क्या हुआ बहना, क्या हुआ? उसी टाइम पे दो गोलियां चलती है, गोलियों की आवाज आ जाती है, दो रिसीवर है टेलीफोन का, वो हिलता हुआ आपको दिखता है. Then that culprit, he goes away. Subsequently, that culprit, the wrongdoer, the murderer, has been nabbed by the prosecution. Now he is produced in the court. He is charge sheeted. And now, what is the fact in issue? Whether this offender, accused, has committed the murder of that sister or not. That is the fact in issue. But now see, so many facts are connected. They are relevant. How? A call was made from BSNL phone. Then the evidence of that BSNL official becomes relevant to state that, because witness, what his brother witness is saying, sir, at 11 o'clock I had received call from my sister stating that भैया भैया मेरे जान को खतरा है, कोई तो भी घर में आ गया है. And I was at the relevant time in that particular square, which is 1 kilometer away from the spot of the incident of murder. In order to establish this factum that he was at the relevant time in that particular square, who was having the SIM card of Idea company, the evidence of Idea company wala becomes relevant. Now here, see, the evidence of BSNL company wala to make sure that call was indeed made, the evidence of Idea company wala becomes necessary to make sure to make sure that what the witness is saying is the correct one, because he was indeed 1 kilometer away from the spot of the incident, becomes relevant. Otherwise, fact in issue, whether A has come, which is why the policemen, the investigation agencies, they collect the evidence to establish the link as to, though they are not relevant, but still becomes relevant. Other example, nowadays, the ED is in the discussion. A is apprehended by ED for money laundering. Why? For the B's transaction is necessary. A is alleged to have committed the offences, but what A has done, A has illegally transferred the amount to B, C, D, or B, C, D has used the money of this A. Means there is a money laundering. To establish the money laundering, the evidence of these people also becomes necessary. Either they will be made as accused that they are also involved in the crime of money laundering, or they will become the witness to show that, sir, we have nothing to do. He told me to get the amount to transfer this amount. So in order to ascertain the money trail, the digital footprints are never to be destroyed. One more thing, very important thing, this evidence, or documentary evidence, can be destroyed but digital evidence is never the subject of the destruction. Digital footprints will be forever there. Every accused will try to destroy it, but it will not be destroyed. It can be recovered. There are several means and modes to recover it, which is why the evidence of these people also become necessary. The very purpose of giving this example is to that though facts are not relevant, but they are relevant. One more, and the other example which I am giving to you, that A is an accused for the commission of the murder of B. It is alleged that on 1st August 2021, in a square at Nagpur, RVI square at Nagpur, A has committed the murder of B. This is the allegation. A says, sir, no, it is impossible that I have committed murder for the reason that on the day of the incident and the day and time I was in US Embassy. You can check it out. You can verify this fact from the US Embassy also. CCTV was also installed there. You can get it verified. Now see, what is the fact in issue? A has committed the murder of B. But where was A at the relevant date, time and place becomes relevant. What was he doing there in USA? That also becomes relevant to PLEA, because if a person who is on the day of the incident was in USA and his presence was physically there, it is highly impossible that he would have committed the murder at RBI Square at Nagpur on the same day. So one fact is proved. What is that fact? That his presence in USA, US Embassy in USA, once his presence is proved there, automatically this will be disproved that he has committed the murder. So relevant. In fact, what he was doing in US, it is not relevant, but it becomes relevant because of the facts and circumstances. So we will have to prove the facts which are relevant. Sometimes facts are irrelevant, still becomes relevant because of the connectivity. And therefore, commonly in trial court, it happens that when the evidence is tendered, the other side takes the objection, sir, what is the relevancy of this fact? Perhaps this will be absurd to answer what is the relevancy of this evidence. Ultimately, relevance is to be decided by examining all the entire evidence, not by giving answer in yes or no. So the relevant evidence is to be tendered before the court. Irrelevant evidence is not to be considered. It will be the domain of the learned judge to decide whether this document is admissible or not, whether this evidence is evidence is admissible or not. Coming to the topic of the other topic of the documentary evidence. When we talk about the documentary evidence, there are certain things to be kept in mind. The document which is admitted by the other side, A has claimed to be the owner of property, which is the suit property, and the defendant says, yes, sir, he is the owner of the property. Then facts admitted did not be proved. Section 56 of the Indian Evidence Act. Facts admitted did not be proved. This is common because we what we call it, the admission is the best evidence insofar as judicial proceedings are concerned. And if the oral evidence is to be proved, then it must be the direct evidence. If I have seen any incident, then I become a witness and I have told this fact to B that I have seen the murder of so and so person while coming from office to my home. I have told this fact to B and B becomes the witness. Law says what B would say in the or would be saying in the court, his evidence would be called as a hearsay evidence. I am the direct evidence. So law expect that if it is a case of oral evidence, it must be the direct. And there is an express provision in section 59. All facts except the contents of the document or electronic records may be proved by oral evidence. All facts can be proved by oral evidence except the contents of the document or electronic record. So what law suggests, if a document is to be proved, then there must be document. Now the oral evidence must be direct. I have introduced you that oral must be the evidence must be the direct, means the best evidence. Best evidence is the direct evidence or ocular evidence, eyewitnesses. And how to prove the documents? 61. The document must be proved. The contents of the document may be proved either by primary or secondary evidence. Either by primary or secondary documents. Then next section talks about what is primary evidence. Then section 62 comes into picture. 62 says primary evidence means the document itself. Primary evidence means the document itself. If it is a case between A and B in respect of an agreement to sell property, expressly agreement has been reduced into writing, that agreement itself sale deed has been executed between A and B, that sale deed itself, that is called the primary document. Sometimes it happens that an agreement to sale has been executed, both parties have signed, thereafter photocopies of it are prepared, original is kept with the vendor and the photocopy is given to the purchaser. Original is the primary document, photocopy is the secondary document. Original, you got it? The original is the primary, photocopy is the secondary. But an agreement to other example, in what way it becomes primary and when it becomes secondary. An agreement to sale has been executed. It has been photographed now. Two photocopies are prepared. And on both the photograph copies, both the parties have signed. There are original signatures of each one. Then both are primary evidence. In earlier example, agreement was executed on original, thereafter signatures were made, thereafter photocopies were prepared. Original was the primary and the photocopies are the secondary. In a second example, documents are prepared, thereafter both the parties have signed, then each one is the primary evidence. Best example, the law books, the newspaper, law books, they print in bulk, each one is primary. SCC or AIR as the case may be, or MHLJ, each print is the primary evidence. Although subsequent copies may be photocopies of those, but they are prepared in a one sequence and their newspapers, each print is the primary evidence. Secondary evidence, in order to see that, section 63. Secondary evidence means what? Certified copies. All certified copies are secondary, because certified copies are prepared of the document which is original is kept somewhere in public office. Therefore, certified copy is always secondary. Then copies made from the original, photocopy. Then, for instance, a video, CCTV video footage has been captured in hard disk. It is there. Now it is copied from that hard disk into a pen drive or CD. That copied version into CCTV or pen drive is called the secondary evidence. Then copies made from or compared with the Xerox copies, they are the secondary evidence. Original, primary, copy, secondary. And in order to prove the secondary evidence, certain formalities are there. What the law says, document must be proved by primary evidence, except in cases hereinafter provided. If a document is to be proved, then first thumb rule is it must be the original one, the primary evidence. But there are certain exceptions. Section 65 of the Indian Evidence Act provides those exceptions. For instance, if the document original is in the custody of the other side, wherefrom I will bring, then therefore law permits that if the original is in the custody of the person against whom document is to be proved, then secondary is permissible. Then if the original is lost, secondary is permissible. There are certain categories have been provided under section 65, which would say that these are the documents which, though they are secondary evidence but admissible, can be tendered in evidence. For instance, law also provides, for instance, the Registration Act expressly provides that if a certified copy of index registered under the Registration Act is placed before any court, then it shall be admissible in evidence. Original is in the office of the sub-registrar, wherein the registry has been done or seal deed has been executed. That is called the original is there. Then extract is admissible. Other example, that it normally happens in the business of the banking business. The statement of the bank, original statement, original register is always kept with the bank. See, now they have online data, they have online entries, but before few years back, there used to be big registers, entries giving credits and the deposits, withdrawal, they had to maintain. And if any dispute arises, the photocopy of it, which is duly certified, was to be produced before the court, not the original registered. If the original register of a bank is taken from the bank and is produced in the court of law, what will happen? All entire transactions of the bank will be stalled. There will not be financial development. Therefore, what the Bankers Book Evidence Act provides that even if the extract of the bank is produced before the court, it is admissible in the Evidence Act. So whenever any law provides that extract or the certified copy shall be admissible, then secondary evidence will be always permissible in the court of law. So when law says that certified copies will be admissible, then it is admissible. Birth and Death Registration Act also provides. So if a certificate is issued under the said act, it shall be the proof of that birth or death, as the case may be, to prove the birth, death, or date of death in before any judicial proceeding. Coming to the topic of this public document and private document. Private document has not been defined, but public document has been defined. Section 74 talks about public documents. The wordings which the statute has employed is document forming the acts or record of the acts of the sovereign authority. If a document is prepared by the sovereign authority, or while discharging duties as a sovereign authority, or while functioning as a sovereign authority, is public document. Second category of official bodies and tribunals. Official bodies and tribunals. Tribunals, you know, industrial tribunal, labor tribunal, the administrative tribunals, tax tribunals. There are a number of tribunals. Green tribunal. Official bodies which are constituted official by the act of parliament or the state legislature. And third one of public offices, legislative, judicial, or executive of any part of India or Commonwealth or foreign country, or public offices. So to simplify these words, any government office, any local body office, or any office which is constituted by the act of parliament, state legislature, or by virtue of government decision, any office is created, they are the public bodies, and the document prepared by them is the public document. All other are private documents. If as an advocate you have prepared a document, you have signed it, it is a private document because it does not come within the meaning of the public document. Now see, example which I am giving to you, that A and B have entered into sale deed. A has sold the property to B. Of course, the manner of transferring the property, the registration of sale deed, gift, or any other means as provided under the transfer of property. But I am talking about the sale deed. A as a vendor, B as a purchaser, they have executed. Execution is C. Execution is a different thing. Registration is a different thing. Executed sale deed. This is what? Private document. They have presented it for the registration before the sub-registrar. Registrar, what he does? He takes entry of that sale deed, that transaction, into his index number 2. There are registers maintained in the office of registrar as provided under the Registration Act, and those indexes are entered into by the sub-registrar, his officials. They make the signature. See now, sale deed prepared by two private individual, vendor and purchaser. This is private document, and the contents thereof are reduced into writing by the sub-registrar office in his register, which is maintained in the office. Those entries are now they become the public document. When the document is registered, now entry of it is taken. One photocopy is also is kept in the office of sub-registrar. See now, two kinds of documents are there. One is whatever is written, the description of the property, vendor, purchaser, detailed document number are reduced into writing in that register extract. It is prepared by those officials and therefore it is a public document. Whereas sale deed is prepared by the private documents. And now sale deed, once it is certified by the government authority, that public official, then it becomes the public document. Other example. Now see, very simple words, if I may say, that understand who is the creator of the document. If it is a public official, public document. If it is a private person, it is a private document. Author, creator, the director of the document, ascertain who is that person, who is the author of the document, that decides the nature of the document, whether it is private or public document. If it is a private person who has executed or prepared a document, it is a private document. And if it is issued by or prepared by the person while discharging official duty, it is called a public document. Author is very important. Other example, a victim of crime goes in the police station, lodges the report stating that, sir, while coming from office to home, somebody has snatched my chain or bag and theft has been committed. He is the victim of the crime. He has prepared a report. He gives it to the police. Then policemen, they reduce into writing in their printed FIR, which is the register to be maintained in the office, in the police station. Then those entries are taken by the police. They sign it. Report which is given by the victim is a private document. Then FIR which is signed by the public official becomes the public document. So is the case of the bank. When you deposit the amount, your amount entry is taken in the register. Then a registered certified copy is a public document because it is prepared by the author is the bank official is the author of the document. So public document, private person has not prepared it, but it is the person who, while discharging sovereign function, official function, or tribunal, court, authorities, government, executive, these are the document prepared by these authorities, public document, except these all other documents are the private documents, and certain presumptions are there in respect of the document. How much and what how much is importance given to the documentary evidence? A person may lie, but documents would not. A person may lie, but documents would not. If A says in the court of law, sir, I have become the owner of this property, I am the owner of the property, no other person is owner of the property. And in order to prove his ownership, he has examined 100 witnesses, and all the 100 witnesses have consistently in one line said, sir, A is the owner of the property. Whereas B has not examined witnesses, he has only one document of sale deed in his favor and one witness on the sale deed who attested the sale deed, defended himself and his witness. Who has become the owner? The court will give fine. Court is bound to give finding in favor of the B because B has document of title. What that is what exclusion of oral evidence as against the documentary evidence. What the if a law says in order to prove the ownership of a document, then there must, or if a document, if the ownership is to be created by document, then it shall be must or it must be created by the documents only, the sale deed, and no number of witness would take place of the documentary evidence, and that much importance is given to the documentary evidence. So A, who has examined 100 witnesses, they are of no use because they shall be excluded in view of the provisions of the Indian Evidence Act because for want of document. If A says I am the owner of the property in pursuance of the sale deed dated so and so, and he has indeed produced the sale deed which is proved by examining witnesses, then he has established ownership, which is why the law provides that exclusion of oral evidence. There are certain presumptions which are logical also. 30 years document, it is 5 years presumption insofar as electronic record is concerned. The logic is that if a document is executed, prepared, well maintained in the office, public office, and the law does not expect a person to be found after 30 years, which is why there is a presumption of genuineness given to the document. Each document, the author has to be examined, and sometimes law says that a document shall be attested. For instance, will, as per the Indian Succession Act, it provides will be executed by the testator bequeathing his property, but there must be attesting witnesses. Then if a will is to be proved, then who will have to be examined? Attesting witnesses there must be attesting witness. In the absence of attesting witnesses, it will not be taken into consideration. Whereas in case of sale deed, attesting witnesses is not mandatory because law does not say that there must be attesting witnesses. But insofar as will is concerned, so whenever any statute provides attestation of a document to be by the witnesses, then such a document has to be proved by examining either of the attesting witnesses. If the attesting one witness is dead, then examine other. Then both the attesting witnesses died, then other tools are there. other mechanism is provided under the Indian evidence and what is to be done. A person who knows the handwriting of the attesting witness or the testator, there are other means and modes to prove the document. But the thumb rule is the signatories on the document, they are to be examined first. If law says attestation, then attesting witnesses are to be examined, they are mandatory. So in this way, one has to prove the documents in the court of law, and no number of witnesses will take place of the documents, because more and more weightage is given to the documentary proof than the oral evidence.
Are WhatsApp messages and emails considered legal evidences?
Yes, yes, they are evidence, but the manner of proving it is provided under section 60, 65A, 65B. They are the special, because 65B provides, notwithstanding anything contained in this act, the electronic record will have to be proved in the manner provided herein under. Means special provisions are there insofar as electronic record is concerned. Because these printouts of the WhatsApp messages, they are the computer output, and therefore they will have to be annexed with the certificate as contemplated under section 65B4 of the Indian Evidence Act. They are also the document within the meaning of the Indian Evidence Act, but there are two different. In criminal matter, the manner of proving it may be different, and in civil matter it will be different. For instance, A has sent obscene message to B. B has complained to police that, sir, I have received obscene message, which is an offense. Circulating obscene message is an offense under the IPC, IT Act. Even if leave apart this IT Act, IPC covers it. How he will prove? He will have to take the printout of it, printout of obscene messages. Now, who has given the authenticity to this printout? Nobody has. Which is why the law says that it should be accompanied with the certificate. Now, see, in fact, this electronic record is a big subject. If you invite me on another day, it will take 2 to 3 hours to introduce you this electronic record only, because I mainly talk about the electronic record. The printouts, the B who has taken the printout, he will have to ascertain that this is the same obscene message which I have received. So he will have to issue the certificate that I use this mobile having cell phone number so and so, my WhatsApp number is so and so, other person's WhatsApp number is so and so, he has sent me obscene message at so and so time. I have taken the printout of the same. There is no manipulation, there is no corruption. The file is not corrupt. So whatever is written is correct to the best of my knowledge and belief. This kind of certificate, and he will have to ensure the authenticity of the data and the information, as well as the system, computer system. So that is in fact different subject, but it is a document, can be proved, provided that it should be accompanied with the certificate. But in most of the cases, no certificate is annexed.
Sir, in case of loss of a registered sale deed, in such a case, original cannot be submitted. It is forged. The allegation is that it is original is forged. There is a loss of original. Now, forensic evidence is inconclusive. In such a case, can the accused take the defense of secondary evidence being valid?
Now there are two contingencies. One is that forgery has been committed, and second is that original is lost. If the original is lost, sure, then you will have to prove that it's lost first. That once you prove that it is lost, then secondary is permissible as provided under section 65 of the Indian Evidence Act. Original is lost, secondary is permissible. Then what would be the secondary? Bring certified copy from the sub-register office. Bring the index copies of the from the certified copies. This will have to be proved. Insofar as forgery is concerned, if in the original there is a manipulation, forgery, then there will be evidence of the witnesses first, who would say, sir, this person had signed in our presence. Vendor or the purchaser, as the case may be, attesting witnesses are saying, sir, we have seen that this person or both the persons have signed the documents in my presence. Then that's all. The forensic report will be an opinion. And remember, opinion will not be always conclusive. It will depend upon the facts and circumstances as to what much value is to be given to the expert's opinion. Law does not say expert opinion is binding to the court. These are the two contingencies. Now, in so far as criminal case is concerned, in criminal case, prosecution has made allegations that accused has prepared bogus document. How he has prepared it is for the prosecution to prove. Accused has a right to remain silent, or he may, if so warranted, take the shelter of defense witnesses. He can call the witnesses on the document to show that he has not committed forgery. Otherwise, he does not need anything to be proved, because it is ultimately the job of the prosecution to prove each and every allegation.
For a certificate under Section 65B, who is authorized to issue such certificate for electronic record?
The person who is in the lawful custody of the electronic record. For instance, you are an advocate, you are going to the court from your office or home. While going to the court, you have witnessed an incident outraging a modesty of a woman, and you wanted it to be recorded. You have opened your camera, cell phone, recorded the version, you have approached to the police station. Now you will have to give that recorded version, that video, to the policeman. You are in the lawful custody of that document. You will copy it and will have to submit it to the police. In that case, you will have to give the certificate. If you give the original, if your camera itself or if your cell phone itself, then you need not give the certificate. Certificate will be required in case of secondary. In case of primary, no certificate will be required. So a person who is in the lawful custody, here in your case, if you prepare a copy of that video, then you will have to issue the certificate. Or if the policeman takes your cell phone in their custody, who takes copy of it, then he will have to issue the certificate, because he has prepared the certificate. Link will have to be established. So insofar as electronic record is concerned, it is a big subject. Certain foundation has to be prepared to introduce this subject.
A will is made on paper by the testator but not registered and also not witnessed. Can such a will be valid, and under what circumstances?
Law does not say the will to be registered. Gift, if it is a case of gift deed, it has to be registered. If it is a case of sell deed having value of more than 100 rupees, it has to be registered. Law does not say will need to be registered, for the simple reason: the person who is on the deathbed, will he go to the office of registrar for registration of will? A person, when the will is executed at the a person who is likely to die on deathbed, and now he has no hope to live or alive, to be alive, and therefore he executes will. Therefore, law says registration is not mandatory insofar as will is concerned, but attestation will be necessary. But there are certain exemptions. If a soldier wants to execute, they are exempted. No attestation is necessary. But insofar as civilian are concerned, attestation is necessary.
How power of attorney can be verified, whether principal as revoked or not? Can managing committee members give power of attorney to his family members to conduct the affairs of society?
A person or principal may execute power of attorney in favor of anyone. Principal, it is the sweet choice of the principal. Now, manager directly saying the family member, something is not matching. If a company board of director gives a power of attorney to any, they can give it to anyone, be it the family member or may not be the member of family. They can give power of attorney to anyone. But power of attorney is also a short act, but several disputes. Indian Contract Act will have to be seen also, because agent principal, these are the concept in Indian Contract Act, not in the Power of Attorney Act. So power of attorney, principal can execute in favor of anyone. But insofar as revocation is concerned, the way in which he has executed the power, a person who gives, he has power to take back. A person who gives the authority has power to take back the authority. He can cancel it by issuing your notice that I hereby cancel that power of attorney. It can be cancelled, but if any interest is created in favor of the agent, for instance, I am the owner of the property, I want to sell my property, and therefore I have entered into an agreement to sell in favor of B. I will sell him property. At the same time, I have executed power of attorney in his favor. I have taken money as a consideration amount. Now some interest is created in his favor. Such power of attorney cannot be unilaterally cancelled. It has to be bilateral. There has to be consent. of that person. If he disputes, if he refuses, then court. Otherwise, simpliciter power of attorney can be revoked. There is no bar. But if an interest is created in favor of the agent, then such a power of attorney cannot be ex parte, cancelled or revoked.
There was a question to you about two scenarios, sale deed being lost and the sale deed being forged. And in the former case, the sale deed being lost, you said that first the person would have to prove that it is lost,
Yes.
and then the second evidence would be allowed.
Yes.
So just as a follow-up question here, this being the case, would it be a good practice that generally whenever an original document like this is lost, so that one does not have problems in future, to just file a police report so that it will be easier to prove that it was lost at a later date?
This is the common practice, that if it is lost, what the common law is nothing but a common sense. He has to prove it's lost. Number one, either he will report to the police. If it is lost in the bus, he will report to the bus stand controller or the person, officer in charge of that bus stop or railway station. He will report somewhere about the loss of the document, or he will make issue a public notice that I have lost my document. If anybody has it or has found it, please send it to me. So loss will have to be proved. Otherwise, everyone will take the shelter of that it is lost, and under section 65 allow me to lead the secondary evidence. So first of all, he will have to prove its loss. Loss mean to the satisfaction of the court.
So that is my question now. So just because I have filed a police report,
Yes,
even at an earlier date.
Yes, you are right.
Is that conclusive proof of loss?
Not conclusive. It is one of the modes. Because it is your natural conduct that you have lost your document, you are expected to report it to the police, because ultimately whosoever finds your document will be reporting. It is expected from that person also to report it to give it to the police, which is why you need to report it to the police. One more thing, as a prudent man, you will issue a public notice inviting the people at large that you have lost, or indicating them that you have lost your document on so and so date, and inviting them to return it to you. Third thing you can do is to report it to the concerned sub-registrar from where it was registered, sir, that on so and so date I have lost my sale deed. You can report it to the sub-registrar also. Public notice.
Okay, but all these things only strengthen your case. They are not conclusive.
Yes, you are right.
Documents produced in reply to a RTI will be considered as secondary evidence?
They are the original documents received. If the original document is in the public office, copy of it is provided secondary evidence. Copy is secondary evidence, but it is not a certified copy. It is not certified. There was confusion, but subsequently judgments came in that it is issued by the public authority, public office. Therefore, it is to be treated as a it is a certified copy. If any document is to be called as a certified copy, then the Indian Evidence Act has provided the manner in which certified copy is to be provided. One has to apply for the copy. He has to pay charges as per rules. One has to check it, sign it, and will have to issue it as a true as per the original record. Hence, this certified copy. As it happens in the court of law, you apply as an advocate. You apply for grant of certified copy. The section officer or the concerned clerk or the assistant superintendent, he issues the certified copy on payment of certain charges. Under Right to Information Act, no such things happen, and therefore they are not the certified copies. They are simply reply in the context of the application as provided under the Right to Information Act.
Whether prosecution can submit additional relevant documents at the time of prosecution evidence which were not actually submitted by the police or investigating agency, or what are the procedures in regard to it?
See, as a thumb rule, prosecution has to tender all evidence by way of charge sheet, final report. Charge sheet word is also not there in the CRPC. Final report 173. They can further investigate and file supplementary charge sheet. Once charge sheet is filed, police role is over. That is not true. They can further investigate. Earlier, the order would be required, but now Apex Court has clarified that no further order would be required. The investigation machinery has power under subsection 8 of the said section to continue with the further investigation, not re-investigation, but further investigation. And by conducting further investigation, the investigation officer can file additional documents even after filing of the charge sheet. This is one. Secondly, if there is mention in the charge sheet itself about some documents, but those documents have not been accompanied with the charge sheet, they can be taken on record, provided that the investigators, the investigation machinery will have to prove to the satisfaction of the court for what reason those documents were not placed on record. Prosecution cannot subsequently procure some documents, but there are certain documents which can be commonly filed subsequently. For instance, DNA report, DNA is taken, report is awaited. CFSL report or forensic science laboratory report, they are always awaited. Charge sheet is filed. After filing charge sheet, those reports come to the investigation officer. Then he files subsequently. This is common thing because they are mentioned and a reference is always given, already given in the charge sheet. So therefore, there is no bar in filing such a document. But all of a sudden, which is document not mentioned by either of the witnesses or by the investigation officer, directly the prosecution through APP, assistant public prosecutor wants to file the document, such a course will not be permissible. Law, in fact, does not permit, so there is no enabling provision.
If the will is unregistered and only the attestation of the signature of only one witness who is dead is received by the executor, while the whereabouts of second witness is unknown, can such a will be probated?
No, it can be proved. It can be proved. There are two witnesses are expected by law. One dead, a person who is alive can be examined. Other dead, both are dead. Then the person who knows the signatures of the testator, the person who knows the signature of attesting witnesses can also be examined. There is express provision under the Indian Evidence Act to that effect. But credibility, there will be issue of credibility. So evidence must be of credence that he is the person who knows. Other facts also will have to be seen. Ordinarily, it happens commonly forged and the bogus wills are prepared once the person dies. So his successors or person who wants the property, they prepare document, backdated documents, which is why this problem court sees with suspicious eyes to such a will. But you can prove it. Yes.
Sir, any concluding remarks from your end?
Topic is good and practical approach will be required to prove the documents, and mere reading the Indian Evidence Act will not suffice the purpose unless you attend the court regularly, unless you see the court while tendering the document in evidence, while proving the documents, while exhibiting the document. Exhibition of document is one more thing. A document which is proved in accordance with law is given marked as exhibit numbers, because there is a manual under which we function, that civil manual, criminal manual. Civil manual expressly provides the manner in which documents are to be exhibited. A document is exhibited, then it can be taken into evidence. When the document is to be exhibited, when it is proved as per law, and therefore one has to take practical experience by attending the trial court insofar as proof of document is concerned. Merely attending the hearing before the higher court will not give you idea unless you attend the trial courts for the purpose of seeing in what manner the documents are tendered in evidence, how they are proved, how the cross examination is conducted, how the documents are taken are admitted in evidence. So my request would be to attend the trial courts for this purpose, and
Okay.
best wishes for you.